Thank you, everyone, for joining us today. I'm Deb Silverman, the chair of the health group at Garfunkel Wild, and I am joined today by my colleagues, John Martin and Carmen Jewell, who are part of a working group that we've put together to assist our clients with implementing the No Surprises Act under the federal law. John is a partner in our litigation department who, among other things, frequently represents healthcare providers with respect to governmental enforcement actions, both at the federal and state level. Carmen spends much of her time counseling clients with respect to compliance matters. I also want to give a shout out to Justine Lee, another member of our group. Justine, who is sitting off camera, has worked with Carmen and have spent countless hours immersed in the weeds of this new law, educating themselves and our firm and providing assistance to many of our clients as they begin the challenging task of implementing the NSA. I want to thank them both. Some of you have asked why we waited a month to present on the NSA. The answer is twofold. First, prior to the law's effective date, there were many presentations out there that walk through the different points of the law. And we didn't think another "this is what the law says" webinar would provide much value. Second, and more importantly, given the complexities of the law and its impact on existing state laws, at least in the markets where we practice, New York, New Jersey, Connecticut, and Florida, which currently all have their own surprise billing laws, we wanted to get a sense of the issues raised by the NSA's rollout and see if any additional guidance would be forthcoming that might answer some of the questions. I'd like to say that by waiting a month, we are now in a position to answer all your questions, but unfortunately, that is not the case. However, we have learned a great deal, and we hope to answer many of your questions during the course of our presentation. If you still have questions that are unanswered, please put them in the chat box, and if time permits, we'll try to address them at the end of the webinar. Next slide. That's a little ad for GW. Next slide, please. Okay, today's agenda. We're going to start with Carmen walking us through the key features of the statutes and the regs. Again, we'll do that quickly. John will then focus on the IDR process, specifically what out-of-network providers might expect to receive if they challenge a plan's payment. He'll also walk us through the lawsuits that are out there, challenging the federal IDR process, and what potentially could happen if some of these laws are victorious or fail. I'll finish up with what we see as the outstanding issues and provide some practical advice. So now I'm going to turn the presentation over to Carmen.
Thank you, Deb, and welcome everyone. So we're going to start with a recap of the No Surprises Act and the applicable regulations that have been implemented to date. Next slide, please. The No Surprises Act was enacted with the intent of protecting patients in the most common surprise bill scenarios. The intent is to fill in the gaps where patients in this country were not protected from surprise bills. Now, this could be because they have insurance through self-funded plans, which are governed by the federal government and not state laws, or because certain states do not have or have only partial surprise bill or balance bill protections. It also creates protections for uninsured and self-pay patients. And for purposes of the No Surprises Act, the self-pay patients are patients who may otherwise have insurance coverage, but are opting not to work with their insurers for the healthcare services. Now, the No Surprises Act consists of various different types of consumer protections. These have to do with network and directory obligations for health plans and disclosure obligations for out-of-network providers and facilities. Under the No Surprises Act, both providers and plans must assist patients in accessing information about the cost of healthcare services. And the No Surprises Act also creates an independent dispute resolution process for out-of-network providers and facilities, as well as a patient-provider dispute resolution process for self-pay patients and uninsured patients to resolve disputes with providers. Next slide. Next slide, please. Oh, thank you. So the No Surprises Act is a comprehensive consumer protection statute. However, there are some things that are not impacted by the No Surprises Act. For example, patients with Medicare, Medicare Advantage payers, or Medicaid fee-for-service as their health care coverage are not impacted by this statute. Those programs have built-in protections for patients to prevent them from getting significant or excessive surprise bills in many scenarios. Under the No Surprises Act, there are still obligations for healthcare providers and patients. So plans still have to reimburse providers based on whatever benefit plan that is in place. Providers are still obligated to collect patient cost-sharing responsibility amounts, and patients are still obligated to pay those patient cost-sharing amounts. The other thing that isn't impacted at all is the No Surprises Act applies to covered services. So procedures, cosmetic procedures, for example, are not really contemplated under the No Surprises Act. And lastly, particularly with respect to non-emergency services, the key question as to whether or not the No Surprises Act protections are triggered is whether or not the facility is in network with the patient's health care plan. Next slide. Now, there have been two sets of interim final rules and one set of proposed rules with respect to the No Surprises Act. For purposes of this webinar, we're going to be discussing the highlights of the Part 1 and Part 2 interim final rules. I won't really be elaborating on the proposed rules, and with respect to air ambulance services, please note that many of the protections that apply, that we'll be discussing for out-of-network providers and facilities also would apply to air ambulance providers. Later on, John will elaborate on some of these aspects. So the key aspects we're going to be focusing on are the balance bill protections generally, calculating the qualifying payment amount, circumstances where out-of-network providers may attempt to have a patient consent to waiving their balance bill protections under the federal law, as well as the disclosure obligations for out-of-network providers and facilities. We'll also discuss the good faith estimate calculation, particularly with respect to self-pay and uninsured patients. And John will provide an overview of the independent dispute resolution process as well, and the status of current litigation with respect to those IDR rules. Next slide. So the No Surprises Act is a very comprehensive consumer protection statute that prohibits balance billing in very specific scenarios. Now, by balance billing, I am referring to the practice of an out-of-network provider that bills the patient for the difference between the billed out-of-network charges and what is the allowed amount. That allowed amount is generally determined by the plan and consists of an amount to be paid by the plan and then the amount that is the patient's cost-sharing responsibility with respect to their agreement with their plan. So that could be the co-payment or the deductible, for example. And those balance bill protections apply for emergency services, whether facility services or provider services, and out-of-network non-emergency services that are provided in an in-network facility. And as I mentioned, the protections also apply for air ambulance services. Next slide. It's important that we understand the hypothetical about a balance bill scenario, and to the extent we'll use any similar hypos later on in this webinar, this is probably the hypo we will use. So let's take an out-of-network provider whose out-of-network charge is $25,000. And let's take a patient who has an out-of-network benefit, but first has to meet the $1,000 deductible. If the payer allowed amount is $15,000, that means the plan will pay $14,000 and the patient, through their deductible, will be paying the provider $1,000. Under the No Surprises Act, the out-of-network provider or facility cannot balance bill the patient for that remainder $10,000. Next slide. So if there is a surprise bill under this act, whether it's a bill for non-emergency services or, bill for emergency services or non-emergency services at an in-network facility, with few exceptions, the out-of-network provider may not balance bill the patient, and the plan has to make sure that the patient is not responsible for anything more than what the patient would have paid had that provider been in-network. Next slide. So we'll start with the protections as they apply with respect to emergency services. This protection applies regardless of the facility's status as in-network or out-of-network with a payer. With respect to emergency services, the providers are prohibited from balance billing for the emergency services, and it is important to note that the definition of emergency services for purposes of the No Surprises Act is more expansive than what we generally consider as emergency services under EMTALA, for example. So emergency services includes pre-stabilization services that are provided after admission and movement from the ED to another floor in the hospital, for example. And it also includes certain post-stabilization services related to that visit. Next slide. It's important to note with respect to the post-stabilization services, this statute is meant to protect patients in scenarios where they may not have a lot of choice as to seeking care from an out-of-network provider facility. So unless the patient is able to decide to choose those services, they will be protected from being balance billed. And there are specific criteria for when a post-stabilization services can qualify for an exception where the patient can consent to waiving their protections. Among the criteria, the patient has to be able to travel without the use of non-medical transportation to another available participating or in-network provider or facility within a reasonable travel distance. They must be able to otherwise satisfy the notice and consent criteria, which I will discuss shortly. And the individual must be in the condition to receive the information in the notice that is provided. And think of the analysis for determining if the person is in condition to receive the information similar to whether or not a person can provide informed consent for certain procedures or services. You take into account the patient's physical state, mental state, as well as other cultural and contextual factors such as language, perhaps distrust in the healthcare system or misinformation. And while it's not specified, it is built into the notice and consent criteria, which I'll discuss, but the patient, where the patient is in a situation where they don't have time to consider whether or not they have a choice, that would be a reason where they would not be able to waive their protections, which means the end result is the provider cannot balance bill the patient. Next slide. Now, the No Surprises Act also has balance bill protections for non-emergency services. So again, this is where the patient goes to an in-network facility, but is treated by some provider there that is out of network. And provider does include more than just physicians. Generally, the provider cannot balance bill the patient for those out-of-network non-emergency services unless they provide notice to the patient and obtain consent that is deemed valid based on the criteria. However, there are some notable exceptions where the out-of-network provider is prohibited from even trying to obtain such consent. Next slide. So for the following ancillary services, under the Federal No Surprises Act, the patient cannot waive their protections against balance billing: anesthesiology, pathology, neonatology, radiology, services that are rendered by assistant surgeons or hospitalists or intensivists, and services that are provided by an out-of-network provider if there is no participating provider at the facility. Ancillary services also includes diagnostic services like radiology and laboratory services. There is no specified list of CPT codes at this time. It's a very broad carve-out. And technically, the way the statute reads and the implementing regulations read, this would include elective procedures. So where a patient is electing to have a service at an in-network hospital with an out-of-network provider. And there's no carve-outs for elective procedures under the statute or the implementing regulations. This is proving to be an area of concern that several of our clients have in states like New York that have comprehensive surprise bill protections and laws that have traditionally excluded purely elective services from the definition of surprise bill. Next slide. So as I mentioned, in certain circumstances, an out-of-network provider may be able to provide notice and obtain consent from the patient to waive their balance bill protections for non-emergency services. Under the federal law and the implementing regulations, this is not intended to be a common occurrence. And the rules set forth very clear guidance and requirements as to what the notice and consent must include in terms of content, in terms of timing, when it has to be given to the patient, and the information that has to be included that is specific to the patient and the date of service. So for example, the notice and consent form must include a good faith estimate of the out-of-network charges, which we will discuss shortly. This notice and consent is not a contract or an agreement that the patient will pay, and it must be signed by the patient, and it can be revoked at any time before the service is rendered. Notably, if a patient does sign a consent form and the consent is otherwise valid, it is up to the provider to somehow notify the payer or the plan that the patient has consented. The reason for this is because under the No Surprises Act, the payer has an obligation to make sure that the patient is not balance billed and needs to be aware if the patient has waived those protections. CMS has actually published a model notice and consent form, and we recommend that providers become familiar with it. It has instructions and breaks down the requirements as to when and how it must be provided to patients. Next slide. Another key component of the No Surprises Act is certain public disclosures that have to be made by out-of-network providers and facilities to let patients know of their rights under federal law, as well as any comparable rights and protections they may have under applicable state law. This public disclosure has to be made in 3 ways. It has to be made on the provider or facility's website, if it has one, in the provider or facility's primary location in a patient-facing area, and it must be provided to the out-of-network patient by email or mail, depending on the patient's preference, but prior to submitting the claim to the payer for payment. And yes, that is when it has to be provided. That's not a typo. And just as with the notice and consent document, CMS has published a standard disclosure statement. It includes a section for state-specific protections. In some states, as we will discuss, the state agency that is responsible for monitoring surprise bill complaints have already modified the forms to reflect the state law. This disclosure, the law and the regulations are very specific as to length and font size and content and what languages the disclosure must be made in. And we recommend that providers use the CMS model disclosure notice, given the very particular criteria. Next slide. And as I mentioned, the No Surprises Act does include protections for self-pay and uninsured patients. One of these requirements is that providers notify these self-pay and uninsured patients of their right to receive information about the good faith estimate of the charges. The good faith estimate is, includes an estimate of expected charges for a scheduled or requested service, including items and services that are reasonably expected to be provided in conjunction with that scheduled service by the convening or primary provider or facility, and any other co-providers or co-facilities that may be involved. Now, CMS has published a great amount of guidance with respect to providing this good faith estimate information to self-pay and uninsured patients. However, CMS recognizes that it may be difficult for a primary convening provider to obtain this kind of information from co-providers or co-facilities. And so CMS has already announced that for January 1, 2022 through December 31st, 2022, it will exercise its enforcement discretion in situations where the good faith estimate notice does not include information about the co-provider or co-facilities. However, it has indicated that come January 1st, 2023, it will be enforcing the disclosure of that information in the good faith estimate provided to the patient. Next slide. So let's assume it's a surprise bill, whether it's a bill for emergency services or a bill for non-emergency services that are rendered by an out-of-network provider at an in-network hospital, or if there was some attempt to find consent, it wasn't otherwise valid for whatever reason. I'm now going to turn it over to John. He is going to discuss the payment process as well as the IDR process and related issues. So just give us a moment, please. I don't know what's going on.
Hello. So, I think what we've demonstrated so far is that the No Surprises Act is a fairly comprehensive effort by the federal government to take a burden off of patients, which is the burden of paying for out-of-network services obtained in certain situations, and to redistribute that burden elsewhere. And the only other places to redistribute that burden is on the providers or on the payers. And in an ideal world, that would be done fairly and equitably. But part of the issue and part of the problems that providers are going to face is that there is reason to doubt that that is going to happen. The process is quite complicated, and there's litigation challenging it, and it's very hard to predict right now what effect this is going to have on reimbursement. But let me explain how it's going to work, at least in the initial stages. So, as it says on the slide, the first step in the process where you have an out-of-network service that's covered by the No Surprises Act is that you bill the provider. You bill the payer, you bill the insurance company. There's no change in that. Now, the No Surprises Act does have certain requirements for what the insurance company, the payer, must pay. However, the only hard and fast requirements relate to agreements with CMS that are called model payer agreements or state law that dictates what they must pay. And none of the jurisdictions that we practice in are parties to those kinds of payments or have those kinds of state laws. So when you don't have those, the payment that the initial payment that the insurance company must make within 30 days is up to the insurance company or the payer to decide. There is no methodology that they have to follow. So once that payment comes in, once that payment comes, they have to pay within 30 days. We start to encounter what's called the QPA, and then we're going to be talking a lot about the QPA in the next few minutes because it plays a central role in determining how much out-of-network providers are likely to be reimbursed, and how central a role is very important. So the QPA is a benchmark of sorts, a federal benchmark of sorts. It's similar to, in state practice, we use the fair health calculation as a benchmark in terms of trying to figure out a fair level for out-of-network reimbursement. In the federal system, they use the QPA. But the QPA differs from the fair health system in a number of significant and substantive ways that will impact out-of-network providers. The fair health numbers are derived by an independent agency whose goal and objective is to shoot down the middle and create a fair number that's fair to both sides. The QPA is determined by the payer. Now, the payer doesn't make it up. It's a complex formula, and I think we'll provide a link if you want to look at it to the 30-page CMS guidance to the insurers, how they're supposed to design this QPA benchmark number. It is mind-numbingly obtuse and impenetrable. But the gist of it is that the starting point is that it's the median in-network rate that the insurer would pay for that service. So sort of going back to our hypothetical where you bill for a $25,000 service, let's call it a knee replacement, in order to decide what the QPA is, the benchmark that we're going to use in deciding what the provider is entitled to, you calculate the median. Now, median kind of takes me and probably everyone else back to high school math, but just a quick explanation, what median means is you line up all of the in-network contracts amounts that the insurer has for a knee replacement surgery, with the most expensive one at the top and the least expensive one at the bottom. So you have a range of numbers there. The median is the middle number. If you have an odd number, it's the exact middle. If there's an even number of charges, you take the two in the middle and average them. But so that's what the median is. It's not the average. It's the middle number. So as you can imagine, even if a payer generally pays a lot more in this higher end, if they have contracts in the lower end, that median is going to be artificially set. So that's the first distinction about it. It does have some objectivity to it, though. However, there's a lot of question and complication about what contracts count. For example, one major issue is whether single case rates count, and they don't now, and that's one of the issues in the lawsuits. There are different types of contracts. There are factors that are considered in whether or not a contract counts. But the most disturbing part of it, the two most disturbing parts, is that it is fully calculated by the payer. It is opaque. The payer does not disclose how it was calculated, and the providers cannot challenge it. Even if you get into the IDR process, if you think the payer is not accurately contracting their median in-network rate, you can't challenge it. Your only remedy is to make a complaint to the Department of Labor and hope against hope that they do something about it. And the other problem with the QPA is that because it is so complicated and because the formula is so obtuse, there is plenty of room for manipulation, which is not, I'm not suggesting misrepresentation, but there will be an incentive among insurance companies to structure their managed care plans in a way that that median is lower and lower and lower. They're going to want to have a lot more low-end, individual high-end contracts, lump the low-end contracts together to move that median down. This is something that's pretty much entirely within the ability of the managed care companies to determine what their contracted rates are going to be and how their contracts are going to be structured and how that's going to affect their QPAs. But it will not be difficult for them to engage in practices that will lower the QPAs. So now let's get into the IDR process, and we'll talk about the role the QPA plays. So as I said, within 30 days, you're going to get an initial payment. Initial means a good faith estimate of what a fair payment is for the entire services being billed. It's not an installment. It's not the first payment and you'll get more later. However, it's up to the payer to decide what it is. Now, CMS has left it up to the payer under the theory that the payer will try to make a substantial payment because the payer will not want to have to go through the IDR process, so they'll try to satisfy the out-of-network provider. They won't lowball it. However, in my experience, that's not the way payers behave. They do not try to make things easy either for themselves or providers, and they're more than willing to lowball and force everybody into IDR, since the payers will have little units set up to address the IDR process, and it'll be a cost of doing business. The burden on payers will be greater going to IDR, especially smaller individual providers will be greater, especially smaller individual providers. So when you get that payment, whether it's the QPA, which they're free to pay, less than the QPA, which they're free to pay, or more than the QPA, they're going to tell you what their QPA is. So you're going to get a check and you're going to get a statement of what the QPA is. So you'll know right away whether they went over, under, or stayed at the QPA. They will certify that the QPA is accurate, for what that's worth. They will then tell you that you may initiate the dispute resolution process within 30 days of receiving the payment, and they will give you information of who at the provider to contact to initiate the process. So you have 30 days to initiate the process. Now, obviously, when you get that payment, and then we'll talk about the $25,000 bill where you get $15,000, $14,000 from the plan and $1,000 from the patient. If you're happy with the $15,000, that's the end of the game. You don't ask for IDR and you go forward. Another possibility is you're not happy with the $15,000, so you start the negotiation process. If during the negotiation process they offer a little bit more and you're satisfied, that's the end of the IDR process. Where things get interesting is where after 30 days, whoever brought the IDR, whoever brought the case to IDR is still not satisfied. At that point, at the end of the 30 days, you have 4 days to begin the formal IDR process. There is a form issued by the Department of Labor to initiate that process. In initiating that process, you have to send that form to the payer, and you have to file it using the federal IDR portal, which is not yet operational, but we suspect will become operational any day now. In addition, at the time you file that document saying, I want to go to an IDR, you have to select an IDR entity, and you have to pay half of the administrative fee for the IDR entity. At the initial stage, the payer and the provider each pay half. At the end of the IDR, the prevailing party gets reimbursed their half. But at the initial stage, both parties have to pay half. So in that 4-day period, after the 30-day negotiation period ends, you have to serve this notice and file this notice. Within 10 days, you have to submit your offer, expressed as a dollar amount, what you're willing to accept, as well as an explanation, as well as your explanation of why you think this is a fair amount as opposed to what you've been paid. The other side has to do the same. They have to submit their offer and an explanation of why they think it's fair. And the dispute resolution is baseball-style dispute resolution. The arbitrator or the IDR has to pick one of the two offers. Whichever offer gets picked, you get, if there's a payment required, either a refund to the plan because the IDR decides you've been overpaid, which should be rare, or a payment to the provider. It has to be paid within 30 days. Loser pays the fee, and absent fraud, that decision is final. So where the real interest is how is the IDR supposed to decide which of the two proposals to take? So the statute has a list of factors. Next slide. So the statute has a list of factors that it says the IDR shall consider in deciding which offer to take. And not surprisingly, the first thing on the list is the QPA. However, the statute says there's a lot of other stuff that the IDR has to consider, particularly things like training and experience, sort of quality of the provider, patient acuity or complexity of this particular procedure versus a normal knee replacement operation. For a facility, a hospital facility, it's teaching status. And then the final factor that's a little bit odd, but it's in there, which is whether or not the out-of-network provider has tried to get in-network and not been able to. And there's things that they're prohibited under the statute from considering, like usual and customary charges or Medicare rates. So if you look at all that list of things and you think, all right, this is what they're going to be considering, I've got some arguments in there that I can say, give me more than the QPA, even if I think the QPA isn't fair. What I can't do is I can't argue that the QPA was wrong, incorrectly calculated, et cetera. That challenge is not available in the IDR. So I can only say the QPA is a starting point, but look at all these factors I have. You should give me QPA plus X. The problem is, and the litigation is mostly about the fact that CMS, first of all, did not put out the regulations for notice and comment. They waited until October to announce them, and they changed the process. Under the regulations, the IDR entity, and this is a quote, must select the offer as the out-of-network rate that the IDR determines best represents the value. They must select the offer that is closest to the QPA. And only when the two offers are equally apart from the QPA can they choose one or the other. The only exception, so if you want to argue against the QPA or argue, the only exception is you have to establish by credible evidence, has to clearly demonstrate that the QPA is materially deficient. So it places a tremendous burden on you and a tremendous presumption on the QPA, which the statute does not. And it sort of delegates these other things to almost afterthoughts. To making things even worse, it says to the IDR, if you don't choose the offer that's closest to the QPA, you must write a decision and give a detailed explanation why you did that. So that makes it even harder for the IDR to choose anything other than whichever offer is closest to the QPA. So the regs have basically taken what the statute says is a wide discretionary decision by the IDR and circumscribe that discretion so that these decisions are going to almost always be very close to the QPA. And as I mentioned, the QPA is something that I think providers should be concerned about. That is where the litigation is focused. Most of the litigation, there's 6 cases pending. Next slide. Oh, there it is. So there's 6 litigations pending in federal court right now. All of them, to some extent, raise this issue. Several of them focus much more on ambulance air medical services, but the important one right now is the Texas one. It's the 3rd one on that list. It's the first one that was filed. The issue is very, very straightforward. It's what I just discussed. It's whether CMS was entitled to avoid the notice and comment, which is very questionable, and whether CMS overreached by passing regulations that seem contrary to the statute. That case has been fully briefed and it's set for oral argument on Friday morning. And I think we'll provide a link to that in our email. That will probably be the first decision. And given that this process is going to start operating probably within a week or two, I mean, there's a need for some resolution of these cases quickly. And that case will probably address this, I mean, presumably, unless the judge finds some reason not to decide, will address this issue. Either it will say procedurally these rules are defective because they didn't follow notice and comment, and then we'll go through notice and comment, or they will strike them down as inconsistent with the statute. Now, as a litigator, I'm always loath to predict outcomes of litigation, especially when the federal government is on the side with a worse argument. But in this situation, the arguments in the case that I've looked at, and in the other cases as well, seem to strongly favor the providers here. The providers are arguing that the statute should have priority over the regulations, and they're arguing that there's no excuse for something this significant not being subject to notice and comment. I've read the counter arguments by the government, and let's just say that I will be tuning in on Friday morning to see how those counter arguments are met with by a federal judge, because I suspect they will have a great deal of difficulty defending the process they have set up. One other point I want to make, which again, this is not, I don't believe, the subject of much litigation, but in addition to deciding the payment amount, at the initial stages of the IDR, when it's filed and the initial notice is presented, the first thing the IDR has to decide is this case eligible for the federal IDR? And that brings up the question of we are going to have cases that appear like they might be eligible for the state IDR, which would make them ineligible for the federal IDR. And that involves a complex preemption scheme, that the interplay of state and federal IDRs and statutes. And my partner, Deborah Silverman, is now going to address that issue.
I'm back. Before I get on to the preemption analysis, I just want to give a couple of administrative points. If we've gotten some questions, are you going to get a copy of our slides? Yes, there will be an email sent to all of you who are participating. You'll have a link to the slides. You'll also have a link to the QPA analysis that John just spoke about, which I'm sure you're all dying to read, 30 pages of dense prose, but that's coming your way, as well as the link to the oral argument of the Texas lawsuit. It is call-in only, so if you're interested, John will be listening, we'll be listening to see where this might go. I think another question that John raises is, okay, what happens if the federal government puts the stop button on the federal IDR process? I don't know. I don't know what's going to happen with these cases at this point in time. So stay tuned, there's still a lot more to come. Okay, so let's get back to this preemption analysis. You have state law that has always governed fully insured plans. And we always say that insurance has always been left to the states. Now you have a federal law that has provided these very broad protections, consumer protections, as to when a patient can be balance billed. So think of the NSA protections as a floor. The feds have said, you state can make things more prescriptive, you can provide additional protections to consumers, but you cannot provide less than what we have. What they haven't said to the states are, you have to modify your laws, or you have to change them so that you are completely consistent with the federal law. What it seems to us is going to happen is that the federal law will step into the breach. They've stepped into the breach here because the states cannot regulate ERISA plans. Feds can. Now we have the federal IDR process. But it's interesting because there are states out there like New York that where the Department of Financial Services have issued guidance trying to sync the two laws. They're not necessarily, they're clearly not. New York State's law and the federal No Surprises Act, they don't even define a surprise bill the same way. But there is effort on the part of New York State to go out there and provide information that will help New York State providers deal with the two laws at the same time. As of this morning, the other states that we provide legal services in, New Jersey, Connecticut, and Florida, have not issued similar guidance. But what we did find that's been published on the CMS website are two letters from CMS to the governors of Florida and, as applicable, to Connecticut. And these letters are in a response to a survey that we assume that CMS sent out to all the states, which were asking about their state laws, if they have them, and what the scope of those state laws are with respect to balanced billing. And the focus of the letter that CMS sent to Connecticut and to Florida are really about enforcement of the law. To what point of the law will all the protections in the NSA are going to be enforced by the state, because the state laws cover all these issues, and where are the gaps, and where will the federal government step in? And it seems clear to us that the federal government will step in to make sure that patients are protected to the full scope of that federal law, which to me, I mean, I've been practicing a long time. I have never seen the federal government actually step in and handle issues on fully insured plans, which is what appears will happen, unless, of course, one of these litigations stops the federal IDR in its track. Okay, so we talked about, think of the NSA as a floor, and I want to talk a little bit about New York. So we can have the next slide. Next slide. Oh, sorry. Okay. So New York State has had a surprise bill in effect since 2015. And the way it differs primarily from the federal definition of a surprise bill, it's really based on disclosures that have been made to the patient. And as long as these disclosures are made, the patient is not deemed to have received a surprise bill. Federal law has made it seem that the only way to prove that it's not a surprise bill is if you actually have a patient's signature on a very specific notice and consent form. There's no talk about the obligation to get that notice and consent form signed. So in New York, historically, elective services were never considered a surprise bill. If a patient decides 3 months prior to getting spine surgery to select a specific spinal surgeon who is not in network, that's not a surprise bill, using the common sense of the word surprise. But under federal law, if that patient doesn't agree to be responsible to be balance billed, that particular claim, if the surgeon is not reimbursed at a level that he or she feels is appropriate, can go to IDR. Go to next slide, please. New York did issue some guidance conforming the New York State process. They expanded services that are inclusive now under under the state IDR process. The scope of the providers who can access the IDR process have now been expanded. It's not just for physicians. So in that way, by rulemaking, or not even by rulemaking, by issuing guidance, DFS has said, okay, we're going to sync up the state process with the federal process. What they haven't done, and this is to me the most interesting, is they have not changed the definition of what a surprise bill is. And, you know, as a matter of law, they probably can't, because that was a legislative determination, so that would have to be changed by New York State's legislature. So we have DFS at this point trying to marry the two laws. Next slide. And just last week, if you're interested, we have the link to the New York State now has a new page, new web page for the IDR. On that page, you're going to find the certification form that a patient must fill out if the patient is pursuing dispute resolution, an application if a provider wants to challenge the payment received from an insurer, and there's also the how to file the IDR portal is right there. So they've made a very easy access website that should benefit both patients and providers. Next slide. What I want to point out is the language on one of the forms. And this is a quote, I believe it's from the medical bill certification form. And it's clear by this definition that New York State is still hanging on to its definition of a surprise bill. Because if you see this, the line that says, you did not choose to receive services from an out-of-network provider instead of from an available in-network provider before you went to the hospital or the ASC. This is not the definition under federal law, right? Federal law, as I said earlier, you need to have signed, you as a patient had to have signed a form that said, yeah, I knew and I accept the obligation to be balance billed from this provider. By signing that form, the patient is then taken out of the process for payment, and the provider is left with only going to dispute resolution, the IDR process. By not signing the form, if under New York law, it technically would still not be a surprise bill if all the disclosures were made. And we've been asked this question by a number of clients. If you're not available to pursue IDR under the state law, can you bring it to the feds? And based on those very dense letters that CMS wrote to the states, Florida and Connecticut, we think the answer here is going to be yes, that the federal government is going to accept disputes that are not otherwise available through the state process. Let's move on now to what questions remain. So, we were having a little bit of technical difficulties here. You may hear some disembodied voices right now rather than us moving around and getting in front of the camera. Our camera was not moving. Anyway, what questions remain is really what's the scope of the NSA at this point? Carmen, I hope we can hear you, but can you explain what's happening now with the expansion potentially of the NSA?
Sure. So as I have discussed, these were, the regulations are two sets of interim final rules and a set of proposed rules. And in the two sets of interim final rules, CMS did say that or HHS rather, was soliciting feedback from and input from stakeholders. So for example, as I mentioned, certain for ancillary services, non-emergency ancillary services, you cannot try to even obtain consent for a patient to waive their protection from being balance billed. CMS solicited feedback as to whether or not certain ancillary services could potentially be subject to the notice and consent exception. Or with respect to diagnostic tests, maybe certain types of tests could be carved out of that notice, carved out of that prohibition on balance billing. There was also a request for feedback as to when the notice and consent had to be provided to the patient. So as the rules currently read, you have to provide, again, for non-emergency services at an in-network facility, the out-of-network provider has to provide notice and obtain consent at least 72 hours before the service is rendered, or if it's a same-day appointment, at least 3 hours before. So, stakeholders, providers may feel that 3 hours is too much time for a patient to just be waiting around for the 3 hours to lapse after they sign the consent. However, patient advocacy groups may have a different point of view and feel that 3 hours is by no means enough time because a patient is already in a gown in the hospital and may feel pressured to consent and waive their protections. So there is potential change down the road, but it's unclear exactly how much would change.
Thanks. The others, go ahead,
I was
John.
going to say, I have a couple of questions that people have asked that I think are pretty straightforward. One is, and I think is somewhat relevant. Does insurance, I tried to mention this, does insurance have an obligation to pay the QPA initially, or is it that QPA is determined during an IDR? So it's an interesting question, two parts. The QPA is determined before the payment is made, because when the insurance makes the payment, they have to tell you what the QPR is as well. So they pay you $10,000 and they tell you the QPR is $9,000 or $10,000, whatever it is. So the QPA is determined. However, the initial payment that the insurance makes, again, unless you have a model payer agreement, which none of our states do, or state law, which none of our states do, is completely up to the insurer. CMS is considering putting some sort of rule in place that would require that they at least pay the QPA, but they haven't done so, as I mentioned, because they believe that insurers won't try to lowball, because insurers will try to stay out of the IDR process.
Thanks, John. Also, I just want to add to that. Another issue is, well, what about those health plans that have out-of-network benefits and have a specific payment amount that's required under the contract that that insurer has with the employer that's benefiting the patient? My take is if the insurer still has to pay at the benefit level that they've contracted for, they can't be breaching their own contracts. So if the out-of-network benefit pays at a level of 160% of Medicare, then that's the payment that they're going to have to make, even at least, right? Regardless of what the QPA says.
Right.
Now, it's the out-of-network provider who says, I'm not contracted with you, I don't have to accept that level of benefit, I think I deserve more. And that's really going to be the fight.
In IDR.
Yeah, but the IDR process. Just in terms of, John really got into it, the impact of litigation could be striking. It could shut down the IDR process if one of these lawsuits are successful. Also, we're still waiting to see, but we expect New Jersey, Connecticut, Florida to have the regulatory agencies down there start to give out guidance, say, yeah, this is how this is going to work with our state laws, like New York has done. But I want to focus mostly more right now, we're running out of time, but on operational issues. First thing, right now, or I should say right now, prior to 2022, an out-of-network provider would provide a service, and the plan would decide to reimburse the patient, which is their right, and have the provider then chase the patient for payment. Under the new law, as long as the patient doesn't sign the notice and consent, where they're on the hook for the entire bill, the provider, the out-of-network provider, must be paid by the plan. And that's a big difference. Now, the issue becomes, how do you, as the provider, when you're submitting your bills, how are you going to let the plan know that the patient hasn't signed the notice and consent or has signed the notice and consent? So that is something we're waiting to see how that's going to work operationally. Some of you, out there listening to this may know that already. Is there some way in the clearinghouse methodology when you submit your electronic claims, can you now press a button and say notice and consent, obtained or not obtained? So we'll see how that's going to play out. Also, how do you know if if the patient's plan is fully funded, meaning it falls under state law, or it's an ERISA plan, and now you're going under federal law? I think these glitches will get worked out over time. It is not apparent as of the last I looked, on membership cards, whether a plan is fully insured or self-insured. I would expect that would be the easiest way for a plan, for the federal government to mandate that a plan put that on the card. Say, self-insured or fully insured, so you know right at the beginning what you're dealing with. Next slide. Next slide. Okay, takeaways. We've got a minute, so we're just going to go through the last bit of information that we have for you. We've gotten a ton of questions. We thank you. We'll see if we're going to put out something that tries to answer some of these questions. Just a couple that I noted that were popping up on the screen as my colleagues were speaking. Office-based surgeries are not part of this. Remember, that's still a private physician's office. The NSA is only applying to services provided at an in-network facility by an out-of-network provider. Was one I saw. Another quick question I saw was one about preventative services. Again, those are services typically provided in a provider's office. Something that would be included with going to an outpatient department for a colonoscopy, let's say, that would potentially be included. All right, finally, what do I suggest you do as we watch this whole process play out? Consider submitting a couple of test claims to the federal IDR when it opens, so you get a sense of what you're going to be reimbursed, and whether or not you should continue to maybe decide to have that patient sign the notice and consent. I know there's fear that with putting down that good faith estimate, patients could be scared away from going to out-of-network providers. But remember, signing the notice and consent does not mandate that the patient be balance billed. It just gives the provider the right to balance bill. And why is that important? It's important because it creates leverage. And when a payer knows that a patient is on the hook, they are more apt to deal with the provider directly. Remember, they want to keep their employer groups, their customers, happy. And when there are fights about reimbursement on the self-insured side, it is not something that the plans really like to have to go back to their customers and say, well, you know, we didn't pay enough, we're an IDR, you're getting calls from the patient, and they'd like to keep that, you know, they like to keep their relationships with employer groups actually very smooth. We're suggesting that you should also conduct some training and provide a written summary for your office staff, especially the staff that faces the patient, so that you're consistent. Whoever is speaking to a patient about a good faith estimate or providing disclosures or answering questions, is that you're consistent across your offices. And finally, the long-term impacts of the NSA, well, this is when we take out our crystal ball. I would have to think that I fear for the downward trend of reimbursement for out-of-network providers because of John's analysis and basically that the QPA, how it can be structured to drive costs down for out-of-network services, which means there's a push now for out-of-network providers to become in-network. And I have been in the managed care world since it came to the East Coast. I've been doing this a very long time. And I am now representing providers who historically have always been out of network, and they are very interested right now in becoming in-network. So, you know, time will tell. We ran a few minutes over. For those of you who stayed on, thank you very much. And, you know, expect more information from us as this continues. So enjoy the rest of your day. Thank you.